Welcome to another episode coming to you live from Studio G. I'm Clint Goodman with Goodman Law Group, and today we're here to discuss open meeting laws. Today's discussion is going to be the basics of open meeting laws. So if you're an experienced manager or have been on your board forever, you might want to go to a different class. But today's conversation is going to be the basics dealing with notice, how to notice a board meeting, how to run a board meeting, some of the caveats between email voting and the open meeting laws, and a basic discussion of when you can close a meeting to discuss executive items. Again, I'm Clint Goodman, and I look forward to having this conversation with you today. If you want to know where to go to search the statutes, we have this really cool app you can download from the Apple Store or from the Android Store. Just type in Goodman Law Group, you should find it. And there's this place where you can search the statute by keyword. So there's books out there with statute books and things, or you can go online to the legislature's website. But the problem there is you can't really search by keyword. So if you know you're looking for the statutes related to open meetings, for example, you just can't find the statute by knowing the keyword open meeting. But you can do that here. Here's my app where you just type in open meeting, and then it would go right to the two main statutes we're going to talk about today. The first statute would be the Condominium Act if you're a condominium, and that is 33-1248. That's the statute number. So if you were to type in open meeting in that keyword, it would pull up 33-1248. And for planned communities, the statute is 33-1804. So some of the questions that we have from managers or new directors, sometimes homeowners that don't understand the law, is when does a board meeting actually have to take place? We start off with the notice requirement, and we start off with the policy statement in the open meetings law. If you scroll to the very bottom of both the Condominium Act and the Planned Community Act, those two statutes that I cited, you're going to find a policy statement where the legislature, in creating the law, said to the courts specifically that it's presumed that all meetings are supposed to be open to the members. So that's the starting point. Any meeting that a board has needs to be open to the membership of the community association so that the members have a right to attend and to comment at a certain point. So first things first, if you're going to have a board meeting, you need to notice it. The statute requires at least 48-hour advance notice. So the first you look and see, okay, what do our bylaws or articles of incorporation or CC&Rs require by way of noticing an open meeting? And that is at least 48 hours under the statute. So if your bylaws say you have to notice a meeting at least 72 hours in advance, well, you're able to comply with both the statute now and the bylaws, so you notice it for at least 48 hours in advance, or 72 hours in advance, sorry. But bottom line is you cannot call and notice a board meeting, an open board meeting, any less than 48 hours in advance unless it's an emergency. If it can't wait the 48 hours under the law, then you can have an emergency meeting, which is governed by different laws, and we'll talk about it in a later webcast. But for now, just note that a board meeting has to be noticed in advance to the membership at least 48 hours in advance. And that notice can be anything the board deems reasonable. Posting on the community board, mass email blast, newsletter states the date and time of the upcoming meeting. You can mail it if you want, but the notice has to be in advance. Now, if the board meets an executive meeting, that too has to be notified in advance. You don't technically have to notice it through newsletter or posting or whatnot. If you're at the open meeting and the board needs to adjourn to executive, you can just say, hey, we're adjourning to executive now. But you do have to identify the provision in the open meeting law that allows you to meet an executive. So both 33-1248 for condos and 33-1804 for planned communities has the exemptions of when you can meet in executive, meaning closed door, kick the members out, and only meet and discuss with the board. And those exceptions are, number one, if you're going to meet with the board's attorney, because you may need to get attorney-client privileged advice that you can't or shouldn't get in the presence of all the members. So you can shut that down under subsection A1. You can close the meeting to discuss personal information of a homeowner. That's A3. I'm jumping around a bit, so I apologize. A2 deals with pending or contemplated litigation. So if you've got a homeowner threatening to sue you, your attorney's not there, but you want to talk about pending or contemplated litigation, you can certainly talk about that in a closed meeting under A2. A4 allows you to adjourn to executive meeting to discuss complaints about your employees, employee salary, or your manager's salary, for example, salaries of your vendors, those things. A5 is the last one, and A5 allows you to close an open meeting to discuss violations of a homeowner in executive. But the caveat to that one is if it's a homeowner appeal and they're there to discuss or appeal the violation to you, and if they say, hey, no, I don't want this in an executive meeting, I want this in an open meeting, then you have to do it in an open meeting under the statute. The con for them, though, is anything you discuss in open now is open record. So if they want to have their hearing in open and now their neighbor wants to see their violation log, becomes open records. So if they want to do things in open, the records associated with that violation hearing have now converted from executive or closed records to open records that anyone can essentially see. Okay, so having said that, when you do have the meeting, a statute requires that you allow the homeowners a comment period before the board makes a formal decision. So to demonstrate how this works as simply as possible, here's the example. Let's say the board wants to hire ABC Landscaping Company to replace XYZ Landscaping Company. A board member would make a motion to hire ABC Landscaping Company. That motion has to be seconded. Once it's seconded, there's board discussion, pros and cons, pricing, whatever the discussion is going to be, and that discussion is among the board. Now, after discussion is over, you turn to the members, and then the members have the ability and the right, statutorily, to talk about their opinion on whether the board should hire ABC Landscaping Company. They can discuss anything they want with respect to the pending motion. So you have to turn to the members for a comment period. Now, the board can place reasonable time limitations on homeowners that want to talk about a specific item before the board makes the formal decision. But ultimately, homeowners do have that right to discuss. A homeowner can't just go off topic. They have to stick to comments related to that motion. So they can't just throw out any old comment they want about something totally unrelated. Well, this has to be comments from the homeowners based on the pending motion. After you give the homeowners the right to comment, then the board makes the formal decision. If they vote 3-2 in favor of changing landscaping companies, then there you have it. Formal board decision was made and has followed the open meeting laws. Last point for today's conversation, if you have email chatter back and forth by and between directors, it could be subject to the open meeting law. Now, there's a legal debate right now as to whether you can continue to vote via email. I frankly think it's very risky. I would prefer you not do it because I know that most judges are ruling it's a violation of open meeting law nowadays. But there are attorneys, including my partner, who say that you can still vote via email because it's not a meeting. And frankly, there are arguments for and against it on both sides of the fence. But ultimately, going back to the open meeting law, if you have a board get together, a quorum of the board specifically get together to discuss, quote, association business, it's subject to the open meeting laws. So a very clear example of that would be, let's say you don't have all of your board members together, but a quorum of you get together, you go to a social event, and in the middle of that social event, let's say you go to dinner all together because you're friends too. In the middle of that, there are 3 board members, you're all there, you're talking about whether to hire ABC Landscaping Company, and you decide to do it then and there. Well, clearly I think that's a decision that should have been done in an open meeting. because you're discussing it as a quorum of the board, and you're discussing association business, which is whether to hire ABC Landscaping Company. If you do that same thing via email, there's a chance you could be burned if a homeowner later challenges you, whether it's the Department of Real Estate or the Superior Court. A lot of the judges now are saying, because of that policy statement at the end, scroll down to subsection G, I think it is, in both of those statutes, the very last paragraph of both of those statutes. Because of that policy statement that's directed to the courts, chances are that you may end up being in violation of the open meeting laws. And until we get case law from the Court of Appeals of Arizona, we won't know for sure whether you can continue to vote via email. But if you're okay with knowing that there's risks, knock yourself out. Just know that you may be a test case, and that makes attorneys a lot of money. So, well, that wraps up our today's discussion about the open meeting laws, basics of open meeting law. If you have any specific questions for your community, please reach out to goodlaw.legal. It's on the banner below here. And you can even email me directly or email my assistant or our head of marketing, Andrea. She'll put that email down here too, as well as my email. Have a great day. Bye-bye.